Welcome to Living Mirrors with Dr. James Cook. My guest this week is Graham Pechenik. Graham is a lawyer who works in the psychedelic and cannabis space. After over a decade of working in patent law in multiple industries, he founded Calyx Law in 2016, a legal practice focused on cannabis and psychedelics. Graham's also editor-at-large of Psilocybin Alpha, where he provides data for their patent tracker and writes about intellectual property in the psychedelic space. Today, we talk about the legal and ethical issues around companies profiting from psychedelics, a topic that will shape how countless people access psychedelics in future. Hope you enjoyed the conversation. Okay, I'm here with Graham Pechenik. Graham, thanks for coming on the podcast.
Thanks for having me. I'm excited to be here.
So maybe we can begin with a bit of your personal background and how you came to work in the kind of space of psychedelics and law.
Sure. So, I'm a patent lawyer. I got my start working for large pharmaceutical companies at big law firms. I did that for about 5 years after law school, and then came back to San Francisco, which is where I am now. I worked mostly for tech companies, particularly like Google and the Android ecosystem. There are a number of big patent litigations called the smartphone patent wars that I was part of. And then kind of got tired of the sort of big 1,000-lawyer law firm bureaucracy and was looking for a way to sort of bring the kind of background I had to something that was more personally interesting. I had a lot of friends who were involved in the cannabis space in the Bay Area. And I went to a number of like cannabis business conferences and saw that there were a lot of people who had cannabis related inventions basically, but either didn't know much about how to patent them or had spoken to people about patenting them, found people at law firms didn't really want to work or were hesitant to work with cannabis companies. So it seemed like a really interesting niche to be able to work with people who were kind of passionate about what they were doing, something that I felt like I had a kind of a unique advantage because I've always been somebody who, enjoyed cannabis and was kind of involved, to some extent in that sort of culture. So I could speak with people. And then, being on my own, I could like offer those services without the, kind of more risk averse concerns of a big law firm. And then that has transitioned to now I actually do almost all of my work in the psychedelic space. That started about a year and a half ago when I both had some of my sort of first cannabis clients thinking about psychedelics, and then also saw that there were a lot of psychedelics sort of startups or I guess kind of circling around and looking for ways to get into the psychedelic space. And I guess to back up really far, my interest in psychedelics started back in college. So my college degree is in cognitive neuroscience and biochemistry, which I chose after my first psychedelic experiences, made me really interested in how sort of my brain worked and how my consciousness was, affected by taking psychedelics. Thought I would actually find some way to work with psychedelics as a scientist, but had a hard time finding like any encouragement. And the professor that I had in neuroscience actually said that like she wouldn't even consider taking LSD until she was retired because she thought it would like affect her ability to do like intellectual work. So I kind of ran up against this kind of discouragement and then also some encouragement because I had been involved in some of the cannabis reform efforts starting like in high school and was, interested in the legalization aspects too. That law school would be a good place to go to like think about working toward legalization of like cannabis and psychedelics. And then the sort of reality of law school loans kind of put that aside. And I've, continued to enjoy both cannabis and, psychedelics sort of personally. And I guess looking back, especially, never as part of a clinical trial or anything, but, therapeutically, one could say, I suppose. So that's always been an interest. And I've followed the science and I've, followed the patent disputes a little bit too. Like back in 2018, actually, I was at a cannabis conference volunteering at a MAPS info table the week after, I think it was Olivia Goldhill's article in Quartz came out about Compass and like the millionaire couple starting a magic mushroom monopoly, something with a lot of alliteration. And telling people I was a patent lawyer, I had a lot of conversations that weekend about people being very upset about the possibility of, companies looking to file patents in this space, what it might mean for this space. And that really sparked in me sort of an interest in kind of following patents in psychedelics. And that was, before I had filed any on my own. but that was something that made me, start actually keeping track of them. So the thing that started then is now the patent tracker actually for psilocybin that was up on Psilocybin Alpha. And now, of course, Compass patents are back very much sort of in the news around their kind of ethics of doing that. And so it's, I'm privileged, I suppose, to still be part of that conversation. So it's something that I've, seen as kind of a through line through what I've done. But so now most of my work is with psychedelics companies, and the sort of ethics around them is something that I think a lot about on a personal level too, because just working, with companies to file patents, and then also, knowing that there is a concern about how patents can be used has, made me want to ensure that the work that I do, is not going to be negative for the space, because, part of what attracts me to psychedelics is, not just the effects that they've had on me, but also the potential transformative effects on society. So, I wouldn't want to think that I'm part of sort of stalling that or making that more difficult through patents. So it's anyways, very long preamble, but I'm really happy to be here in conversation with you, and I'm really delighted that there is this ongoing conversation around patents and psychedelics, because it's it's something that I feel it's an important discussion to have, and I'm fortunate to be part of it. So I'm looking forward to today's.
Yeah, I've personally really benefited from following your work, being part of this conversation, and it's great as well that you have not only obviously the legal background and the personal background of valuing these substances, but also, I mean, personally for me, as someone in that kind of field, the fact you have a kind of cognitive neuroscience, biochemistry background is really cool. That I think you've got the full package of kind of very well rounded when it comes to commenting on this area. So yeah, I've really valued your work.
Well, thank you. Yeah, I mean, it's a lot of sort of serendipities together. I mean, even just coming from the Bay Area and growing up here and having, easy access, not just, of course, to psychedelics, but to communities who appreciate them and understand them. I mean, I feel very lucky to have been sort of placed in all these kind of crossing paths together. So yeah, I'm hoping I can make good use of it and make that of service to sort of the broader space. But so yeah, right. I'm glad this hopefully can be part of that.
Yeah. Well, you're doing a good job so far. So maybe we can begin with assuming no knowledge of the audience and of myself, maybe we can begin with a bit about intellectual property and patents, kind of why they exist and how they function in any kind of space. When we get onto the psychedelic space. Sure.
So patents are one type of intellectual property as a category, which broadly covers just sort of the fruits of creative kind of intellectual enterprise. So includes things like copyrights, people's written or artistic works, like trademarks, which are brands to protect businesses or products of businesses. Trade secrets are generally considered within intellectual property. And then patents, of course, which cover typically inventions is what people see them as, like useful inventions, but there are also other categories of patents. So there's design patents, which are somewhat similar to a trademark, that are more to the aesthetic appearance of something. And then also plant patents, which cover a just specific genetic plant and its clones. But usually when we talk about patents in this space, with one exception, there was an ayahuasca patent that was, I think, from the 1980s. That's a plant patent, but mostly, at least today, the patents that are considered controversial in the psychedelic space, we're talking about utility patents. So those are, new and useful inventions. And the point of them is to encourage the innovation that is ultimately protected. So it's considered to be a bargain between the patent applicant and the government, or I guess the people who give the government the right to grant the patent. So it's an exchange where the patent owner basically discloses what the invention is to the public. So puts that into the greater pool of public knowledge. And in exchange for that, gets a temporary monopoly on the use of what that invention is. So that both is supposed to at least incentivize that disclosure, but also incentivize the activity that leads to that disclosure. So, you can imagine there are, for instance, like pharmaceuticals is probably the best example because that's something where people really argue it wouldn't take place if it wasn't for the benefit of a patent. So, you can think of like the sort of design space or invention space of all these compounds. Like none of these would ever get to market unless somebody could get a way of protecting their investment in taking one of those molecules and putting the research into showing that it's safe and showing that it's effective for some particular indication, and then ultimately paying for all that clinical research and paying for the FDA approval, having some time to recoup all that investment. So that the patent sort of is a mechanism to allow that exchange to take place, to ensure that those types of inventions will happen. And of course, there's a lot of areas I think where it's arguable if that's necessarily true, and there's also other ways where somebody can get that investment back. So MAPS, for instance, uses data exclusivity or will if it gets FDA approval, which is a way for it to get some sort of exclusivity over the sale of something. So there are alternatives, and it's an open question specifically for certain inventions, but that's at least from a general overview, that's kind of like what the bargain is considered to be from a sort of high level.
Right. And so we're talking very explicitly here about a kind of free market context where we're looking to incentivize people to produce something, and they're only going to do that if they're going to profit, right? But then in the psychedelic space, there are other models as well. And I think a lot of people, when they first hear of think of psychedelics being widely available, perhaps for some people, the pharmaceutical model will come to mind, and they'll think, well, this needs to go through the same kind of approval process. It needs to be the chemical, say like psilocybin, needs to be manufactured into a pill that can be administered by doctors. For other people in the space, they'll, maybe decriminalization, where they're just like, well, we don't need that. These are naturally occurring substances, right? So why would we need to have issues around barring access? And so all of this seems we're in the middle of a debate around the ethics of this, right? Which seems to me about not only the issues of, well, who should profit out of something that's naturally given and a kind of ancient tradition, but also, I guess, the idea of prioritizing profit over access. Is that a major aspect of the kind of debate around this?
Yeah, I mean, I think that really is all those things that you summarize are sort of the key points in this debate. So certainly one of them, that medicalization perhaps is not the best route, and perhaps that's not the route we should be sort of prioritizing. And then one, of course, that these compounds aren't in that sort of imaginary design space where somebody has to be incentivized to get them out of there and put them through all this long clinical trial process, because they're already known to us, and they're not just known to us, but they've come to us through this lineage that includes indigenous groups, and includes for some compounds a long history of practice of people who certainly aren't benefiting by the granting of a monopoly over the use of something. And then, yes, I mean, those things tied together too with the questions over access. So if a company gets a monopoly over the use of a particular compound, like what does that mean for people being able to get access to it? Like, is it only going to be sold at a particular higher prices, or through clinics where the thing that people are now doing may be sort of barred from them through this sort of government grant of a temporary monopoly. So yeah, I mean, I think it's a space where it's important to compare the medicalization route with these other alternatives, legalization and decriminalization, and that's something certainly that doesn't really stand as a analogy in the general pharmaceutical space. So it is certainly something that makes the psychedelic space quite different.
Right. And I mean, if someone was to kind of wonder, like, how does a psychedelic pharmaceutical startup make money, would the answer be along the lines of, you just mentioned a kind of temporary monopoly on how you provide it through clinics, or perhaps it's through the manufacture of a particular kind of pill, a particular way of synthesizing it? Are those the kinds of ways that a company would make money in the space?
Yeah, so I think there's a variety of different ways. I mean, the way that would be most important, I guess, thinking about it from a patent perspective, would generally be for these, a patent that covers a particular compound. So that's, it's most similar to this pharmaceutical space. So, and I think that's also what people are looking at, from the investment perspective, because that's where people are really going to, make the most profit. It's because the type of monopoly that you get for a compound allows you to, make something at a very low price and have a very high margin on the sale of it, and in theory, make quite a lot of money. I mean, many pharmaceutical drugs are blockbuster drugs that are making billions of dollars a year, and so that's, I think, conceived of as a possibility for some things. Although, of course, these aren't just drugs that people will, go to their pharmacy and pick up and then take it home. They have, this whole, clinical infrastructure that needs to be built around it, so people can take these as part of psychedelic assisted therapy. So that's certainly going to play a big role in determining like how much companies are making off this, but also just kind of what the business model is. But certainly, if a company is just considering starting like just clinics without having, a protected drug compound, that I think that makes them potentially, like, I guess, less interesting as an investment target, because clinics are probably not seen as being as profitable as a drug compound. But yeah, I mean, there certainly are a variety of different ways you can beyond those, but those would be important ones to think about.
Right. And so I think a lot of people, when they hear about psychedelics, as we've said, these compounds have been around for a very long time. When people hear about them being put into the pharmaceutical industry model, it seems kind of jarring, because you're like, well, you've not discovered this. If you're trying to patent psilocybin, like, this isn't an invention. So is it possible to kind of patent naturally occurring substances? You mentioned an ayahuasca patent around in the 80s earlier.
Yeah, and that's a very unique situation. I mean, I think it was definitely a sort of cultural and like a shock for sort of policy reasons for many ways. And obviously that was something that was considered pretty, despicable by a lot of people, that somebody would try to have a patent on ayahuasca. But the actual grant of that patent was very narrow. So it wasn't something that covered like ayahuasca in general. It really just covered a specific plant and the specific genetics of that plant and that plant's clones. So, you can, I guess, dispute like how kind of relevant that would be to, the practice of just taking ayahuasca generally. I mean, and so I think for that, I guess I would sort of separate the kind of patent policy issues from the kind of broader cultural issues around that. But for natural compounds generally, I mean, so the basics that I think you alluded to for getting a patent it has to be novel, but it also has to be non-obvious. But the first requirement, which is really the core requirement of any patent, is that it has to be something that's new. It has to be novel. And any naturally occurring compound is not going to meet that requirement because, of course, it's already existing in the world. So anything that's ever been disclosed or anything that already exists, a patent can't be granted on it. But of course, there are ways to get patent protection that cover a natural compound if it's part of something else, or if it's something that's inventive has been sort of applied to it. So Compass's patents, of course, are probably the best example of that, where they're not getting a patent on psilocybin, the compound or the chemical, but they're getting a patent on a particular sort of form of that psilocybin that isn't naturally occurring.
Right. So you have, like with the ayahuasca situation, it's interesting distinction you made. So is it a bit like how, people with like genetically modified crops or just with different species of apples, say, a company can have a patent on, you can't grow a golden delicious apple without paying this company, for example. But that's while that might have been the case with this one ayahuasca plant, it's not. Those aren't the kind of patents we're concerned with here, right? We're concerned with unless, there ends up being, magic mushroom farms or something. That's probably when
yeah. I mean, that's
that
possible.
would be irrelevant.
Yeah, and there actually was, I think, also in the 80s, a plant patent filed on a type of psilocybin mushroom truffle. But there haven't been any since then. I mean, it's something that's in theory possible, and certainly there could be other, I suppose, ayahuasca plant patents filed. Although, I mean, hopefully people have learned their lesson that that's something that's going to be reputationally difficult to pursue. But yeah, I mean, I think this is different. The examples you use are good ones because actually Apple plant patents are probably considered the most valuable because that's something where people really do create a brand around a different type of apple, and apples, the way they're grown, they can be easily sort of cloned, and they are all genetic copies. But there are also like Monsanto's patents that cover genetically modified crops. Like those are utility patents, not plant patents, because they cover any plant, and whether or not it's a genetic clone of a particular original one that has the genetic modification, for instance, that makes them withstand the Roundup pesticide, or whatever we'll call it, biocide.
Yeah. And so you mentioned Compass Pathway is this, I think, London-based startup, right, who are big international players now. I think one of the groups that got breakthrough status by the FDA in America, right, to roll out psilocybin. And you mentioned that, so they've not, whilst they've successfully received a patent for psilocybin, it doesn't mean that, if you're someone in Amsterdam where it's legal to consume psilocybin containing truffles, this doesn't affect you, right? Because that's just natural psilocybin. But what they've patented is a lab-based method of synthesizing psilocybin, right, from chemicals. And so that's a claim that that's how the kind of novelty, I guess someone could argue, right, that is patentable.
Yes. So, and that is one of the things that they've patented. So actually in the UK, they have a patent on the process, so the method of manufacturing their synthetic psilocybin. In the US, they have that pending, but it's not been granted yet. But they also have 3 patents that cover this polymorph, which is like a crystalline form of psilocybin. So it's like their sort of GMP formulation. It's like a 95% or more pure formulation of a polymorph. So the polymorph is just like the way that the psilocybin molecules, when they're collected together, like millions or billions of them, pack in like a crystal form. So there's a variety of ways that can happen, and they've patented like one specific way of packing them together. So I think there has been concern whether that way of packing them together would be like the only real way to get GMP psilocybin manufactured, which then would be potentially possible for them to use that to exclude others from getting like FDA approval, because nobody's going to be able to get FDA approval of a psilocybin mushroom. But it does mean that they only have protection very narrowly for that specific polymorph of psilocybin, so that that particular 3D packing structure of the psilocybin molecule in a pure form with particular excipients. So of course, somebody taking psilocybin mushrooms or somebody taking truffles in Amsterdam doesn't have to worry about infringing Compass's claims.
And when it comes to, there have been lots of question marks over the kind of ethical conduct, I think, of how these patents have been sought. And I think one of the main ones was that this compound, I think they call it Comp 360, this particular form of psilocybin, or the method for producing it is effectively the same as Albert Hoffman's method, the first person to synthesize psilocybin. And so there's been arguments that it doesn't actually represent a kind of, they are not the people who should get the credit for this method. It's not a genuinely new step forward.
Yeah. So that, that was a big debate that took place, and their patent, after it issued, was challenged on that basis. And that evidence was like put before a administrative board, who actually decided not even to take up the case, um, basically finding that that evidence wasn't sufficient to show that there was, in fact, like this doubt that they had um, claimed the Hoffman method. But I think, there's certainly some ways to argue that procedure, perhaps, like, both may not have had the, a sufficient amount of evidence to like prove that what Hoffman did was in fact like the same as what Compass is doing, because techniques change, and the sort of ability to do analysis of a compound changes. So that may be the case that there was in the prior art this particular polymorph, but yeah, but I mean that was a challenge that was made to their patent. But it also goes to show, there's been some dispute too, like, well, it's not so bad if people end up getting these really broad claims, because others can just go to the patent office or just challenge them later after they are issued. And I think this is probably a good example of how that's, it's difficult and it's expensive. And, I don't know the bill for that, but it was probably, in the six figures, certainly. And for people that get sued by somebody with a patent, even if that patent is, ultimately going to be found invalid because it was claiming something in the prior art and it wasn't novel, taking something in district court litigation to try to show that it's invalid, that can now be, hundreds of thousands, millions of dollars even. So it's, it's a pretty high sort of barrier. That means that like it is really important for the patent office to grant patents that are, not overly broad and not claiming into the prior art, because, that's really the chance to make sure that those don't get granted, because there aren't going to be a lot of people with the resources to challenge those later. And, it creates a asymmetry between the patent owners and, people who are threatened by the patent. And it's, the psychedelic space is still pretty young, and, I don't know what Compass's intent is and how they want to use these, but in other spaces, in the software space or tech spaces, we've had all these patent trolls who, kind of make it their business model, really. And there's, even ones on the public market who have made it their business model and taken public investment to basically buy up patents and sue others, knowing that there's this asymmetry in the fact that they can usually extract some sort of settlement, because folks just don't want to pay, even $100,000 at the very outset to just kind of investigate and defend a case. So, the possibility of there being sort of predatory actors, patent trolls, who could get their hands on psychedelics related patents and, potentially, cause damage in the ecosystem, is something that, should mean that people now, while these patents are still pending, should kind of pay attention and try to ensure that overly broad patents don't get issued to whomever, even if they're getting issued to people who we think are good actors with their best intentions. They can always end up in the hands of others ultimately. So it's, it is a important kind of thing I think to pay attention to.
Yeah, and the topic of these being kind of non-obvious, that in order for something to be granted, it needs to be non-obvious and novel. As a scientist, I'm who works in the kind of academic space that isn't for profit. It's a lot of these things, it's very clear that you're standing on the shoulders of giants, and there's a lineage of research that goes back decades, and not to mention the indigenous use. But with something like psilocybin, we have kind of the Hopkins research and then Imperial, and then the idea that one should roll this out, and synthesize psilocybin and use it for mental health issues is not it's already there in the academic literature. It's not like, as you were saying in the beginning, that these patents can often serve as a kind of incentivizing new discovery, right? It seems kind of an obvious thing that needs to be done, and to kind of, I guess, there's a bit of a land grab going on, right? Where there's situations like that, where there's money to be made, people can kind of just try their best to claim that they should be the one to profit from it, even if there's not really any significant novelty to the method that they're particularly proposing.
Yeah, I mean, I think that's definitely true. And that's, a failing that's not just something that exists in the psychedelic space. I mean, that's been a criticism of the patent system, for almost time immemorial, at least as far as the U.S. patent system goes. There's Supreme Court cases dating back to the 1800s, early 1800s, talking about this. So this has been something that the courts have tried to grapple with, and there's been a lot of reform efforts in the patent laws, but it's something, because the value of a patent is so great, people will always try to find ways to obtain patents, because you can think of it just almost in some extent like kind of a lottery ticket. Like you file enough patents, you can often get some claims granted, and the value of those claims can tend to be greater than the amount of money that you paid to file those patents. So sometimes it's a strategy that people will take just to see how many patents they can sort of get issued in a particular space. And they, the bigger game in any space is because other people are doing the same thing. Why would you sort of miss out on it? So oftentimes, a land grab is not a bad analogy, because it's kind of an open space. People know that there aren't claims yet filed and granted, so people will sort of try to take them for themselves, because if they don't, somebody else potentially will. But yeah, it's certainly there is something that's, I think, I couldn't tell you how many articles I've read that have been titled it, but it's like patenting inventions or inventing patents. But it's like, yeah, a lot of times people are trying to come up with ways to obtain patents more so than they're using patents to like protect an invention that they've already come up with. So, you can see that as a failing in the patent system, but it's not really a failing in the psychedelic space so much. It's just obviously it clashes more, I think, or is in tension with the sort of ethos that people in the psychedelic space may be, maybe presenting, or that may have.
Right. And I think that point about how some groups will file lots of patents and basically just see which ones stick is really interesting, because, I think it's important to say that when you see the headlines around these things, I think people can often miss whether the patent has been granted or just filed. Sometimes companies will successfully get a patent, or sometimes they'll be filing for something and they won't get it, but it's just an attempt. And I think one case was Compass again, who had attempted to patent pretty much standard aspects of psychedelic psychotherapy, like holding hands with a therapist and soft furnishings. I think, am I right that wasn't actually granted? Right, yeah. And that was just filed?
Right, yeah. So that's only just been published in October, and they actually have another year from the date of publishing before it would even enter prosecution in any countries. So it was filed as what's called like a patent cooperation treaty, or PCT application. These basically just allow somebody to file a single application at a single office. It's like part of the United Nations, actually called WIPO. And then they have 30 months from the date it was first filed before they have to enter national prosecution in different countries. So starting in October next year, we may see it be filed in different countries around the world, like some of their other ones have. And then even from that date, it's going to be a year and a half, 2 years maybe, before it even sees an examiner, unless they can pay or otherwise try to like accelerate the examination. But it may be 3-4 years even yet before there are any issued claims from that. So yeah, that's just a filed application, and the claims often in a filed application will be as broad as anyone thinks it can possibly get. I mean, it's really sort of staking out the furthest sort of boundaries of the territory you think you may potentially get. So some of the outcry, I think, it's definitely warranted, because it still shows that they have a strategy for this. But like ultimately, I think it's unlikely that they would get those sorts of claims. But it's I don't know their intentions, and I wouldn't ascribe any to them. But it does indicate, I think, that they are certainly considering trying to get broad claims, or as broad claims as they can, to cover psilocybin therapy.
Right. So yeah, I mean, I guess that's the concern, right, of monopolization, that they would attempt to kind of limit access by only having them be the people who could provide this.
Yeah, I think so. And there's another aspect sometimes too of filing these broad claims is even if you think you may not get it, it also sort of dissuades others from entering a particular space because it does create kind of a risk to people because they don't know if these claims will be granted or not. And they know now you have the earlier date. So, it can potentially dissuade others from sort of entering that space to compete with them. But I think also, one of the things that was notable about this patent that was different from their granted ones in the US around this polymorph is that with this PCT application, I mean, they covered the use of psilocybin in therapy, just psilocybin. So, if these claims were granted as they stand, that would mean that even under like Measure 109 in Oregon, which allows for psilocybin therapy with just natural mushrooms or psilocybin extract, in theory, if these claims were granted as is, they would also cover like that if it was, in a room with soft furniture and with these other things. So, I think that's part of why, those were seen as being so problematic.
Right. Yeah, I mean, we'll have to wait and see, but not knowing anything about this space, I would be shocked if that was granted that, in a way that prevented, but just based on intuition, I know nothing about this legally, but if it was granted and say you're a psilocybin therapist in Oregon where it's legal and you're using fresh mushrooms, would the risk be that you could be sued by the company for using their technique of interacting with the therapist?
That would be the risk, certainly. And I'd be like one step below shocked. I mean, I've seen certainly a lot of patents be granted with claims that are, fairly outrageously obvious. Hopefully, I think in this circumstance, it's not going to go through unnoticed. So, if it looks like it's approaching a grant with claims that broadly, I feel like there's going to be an attempt like there was with the polymorph patent for people to file some kind of objection to it, which would probably be enough attention for the examiner not to let it through. But yeah, I mean, I would be pretty surprised, I would say. But yes, I mean, if it was granted, that would potentially give Compass the ability to sue anybody who is practicing what's covered by those claims. I mean, so the claims of a patent basically draw your property lines, and anything that falls within them, you have the right to exclude everybody from doing. So if they had a claim that was just using psilocybin in therapy under these sorts of limitations like that are in that claim or those claims, I mean, that would keep anybody else from being able to do that at risk of being sued for infringement. So, in practice, it's unlikely that Compass is, I would think, going to sue individual therapists. They may sue the sort of therapy centers or bigger competitors who are trying to open therapy centers in Oregon. But there's certainly been examples like again patent trolls suing everybody who does something, even little mom and pop shops and stuff, just either trying to get them to stop or trying to get a small settlement amount. But it's obviously it's a reputational kind of risk to consider too. Although I don't know how much they're or how well they are looking after their reputation in this way. So potentially it's something they would pursue. But yeah, it would be surprising to me to see claims of this sort granted.
Yeah, and another interesting area is the idea of using kind of patents for specific disorders that you might treat with psychedelics. And I think Compass also filed a patent for treating anorexia, possibly with psilocybin. And so is that something that's on the table, like specific treatment modalities for specific disorders?
Yeah, and that's an area where maybe they can combine enough sort of limitations. So when I keep saying limitations, like these are the elements in the claims that are kind of individually looked at to see if it's novel or non-obvious oftentimes. And if the things that are in a claim are found to be either not novel or obvious, the patent applicant can add more limitations to it. So, if you have a claim that's just giving somebody psilocybin for therapy in a room with soft furniture, if that's found to be obvious, then you can add something else to it. So, then you can add whatever else you want. There's a water fountain in the corner or some sort of spa music. But so, yeah, I mean, this is another, I think, tack it seems that they're taking from these applications. And they have, anorexia is a good example, but they've filed, I think, more indications, than I even knew existed. There's like pyromania in there, and, skin picking disorder, and a whole number of indications that, I would imagine they're not going to try to take through FDA approval as approved clinical indications, but maybe they would think somebody's going to be using off-label. Anorexia, that's a good example to use because their patent application was filed in, can't remember the exact date, but after their application was filed and before it was published, there were a number of clinical research studies started, one at Imperial College London and one at Johns Hopkins, both studying psilocybin for treatment of anorexia. And subsequent to those two, Compass is also, I think, affiliated with one at UC San Diego. So, Compass was sort of third to start a clinical trial on psilocybin for anorexia, but they have this patent that was filed before all of them. So potentially, like if they had claims granted on that, like what would that mean for the, this other research that's going on? And people oftentimes think that research, should be allowed to be pursued even if there's like a patent granted. And that actually used to be the case in the US, and it is still the case in some countries, but in the US now, actually, like research can infringe someone's patent unless it's being done specifically for FDA approval. So research that's just done as part of a kind of unaffiliated research program that's not specifically for FDA approval would potentially be at risk of being shut down, or I don't know what other kind of like agreement would have to be struck with them to pay a royalty or something. It's also a good example too of the nature of prior art and how difficult sometimes it is to get prior art to a claim. In the 50s, there was a woman who was given psilocybin for anorexia. And this was written up in someone's dissertation in France. And there's a woman, Erica Rex, who wrote about this in a newsletter and kind of brought it to light. But she talked about the fact that this was very difficult for her to get her hands on, and she actually lives now in France and speaks French and had heard about it, but spent quite a long time trying to track down this dissertation, which is it's really right on point. It's psilocybin for anorexia, so this in theory should render this claim not novel. But how would a patent examiner in the U.S. have even been made aware of this, and would they have taken the time to try to find it? And so things that are prior art, and properly so, are often not in front of a patent examiner. And that's, one of the reasons why claims that are more broad than they should be sometimes get granted.
Right. And another area which maybe on the face of it seems a bit less fraught with these kinds of issues is the development of new molecules. Because I know there are people trying to tweak existing kind of psychedelic compounds to have different properties, whether it's seeing things about, attempting to make psychedelics without the trip component, without the kind of the actual kind of psychoactive effects, which I personally don't think is a wise idea, but that's a different conversation. But is this also an area where people are, successfully filing patents for new molecules?
Yeah, and I think that's definitely an area that's less fraught with these ethical issues. Rick Doblin, for instance, has come out and said that this is an area like him and MAPS support as something that's, appropriate to file patents on. And I think that's probably seen by many as an area where, patents are more deserved. And certainly, that's an area kind of like how we started saying the sort of bargain of a patent is meant to encourage this sort of research. That's, with a truly new chemical entity, without patent protection, that kind of research may never get done. So that's, there are obviously some counterexamples. Alex Shulgin was not although he did file patents on some of his claims, so it's not entirely the case, but, there's not a lot of kind of underground chemists who are spending time their own time particularly working with new chemicals, and then certainly not taking them all the way through the FDA approval process. So, there's like certainly bigger conversations to be had about whether the FDA approval process is necessary or is even really appropriate. And, there's an alternate universe where people could be coming up with new psychedelic compounds, not getting them protected by patent, and still find a way to have them tested and eventually potentially even produced. But that's not the world we live in at the moment. So at least for the medicalization route, like this is an area where I think patents have sort of an appropriate place to play.
Right. And another area seems to be combinations of compounds. Like, this is another area where it seems that kind of it's not necessarily a new step forward in that you have, I think there's a patent filed for a combination of MDMA and LSD, which I think is known as candy flipping and kind of underground. Mm-hmm. And also cannabinoids and psilocybin, which is, again, smoking cannabis and taking mushrooms is not, hippies have been known to do both, I would say. This is not something that's like some new, leap forward, but I think both of those has been filed as patents, right?
Yeah, they have. And I mean, I think, this is an example of oftentimes people just looking for different ways to, find something that's protectable around compounds that are already in the prior art. So the like MDMA LSD patent, I haven't, seen it. So I don't know if there's something specific in the way that they're given or the way that they're, formulated or dosed. And the same, I guess, could be said. I don't know the non-public information about the like cannabis psilocybin one, but certainly those two things have been done together. But the way that they're being dosed or the way that they're formulated, potentially there's some patentable invention there. But yeah, I mean, this actually is a problem that the pharmaceutical space has dealt with, and actually where I kind of got the start of my career was working with big pharmaceutical companies. As drugs were coming off patent, they were concerned about losing their monopoly on them and trying to figure out ways to sort of extend that period of protection. Oftentimes when you're making such good revenues from the sale of a drug, you don't want generics to be able to launch very quickly. So there's a problem that pharmaceutical companies have faced, which is, okay, we have this compound. The compound itself has been patented, with these very strong sort of composition of matter claims. What can we do to extend that patent protection? So there are a number of different techniques that pharmaceutical companies take, which is doing things like what Compass did, the solid form, the polymorph formulations, dosing regimens, these sorts of things. And these are now often in the psychedelic space, the strategy that companies are taking from the outset, because they didn't already have a patent covering the natural compound, but the natural compound itself still wasn't able to be patented. So what are these sort of secondary patents one can get on the compound?
Right. And then it might be worth just pausing on that point that to emphasize that these patents the monopoly doesn't last forever, right? You were saying there's a kind of a time limit on it, and at which point you can have generic versions available. What kind of time frame is that typically?
So it's 20 years from filing. So the first non-provisional that's filed, excuse me. So that would be like the PCT application. So it doesn't start from the provisional. The provisional is kind of like a free year. You get the first non-provisional or PCT would start that 20-year clock. So if it takes 5 years to issue, you have 15 years of patent life. If issues in 2 years, you have 18 years of patent life. There are some ways that it's like adjusted. If you have a really slow patent examiner, there's ways you can get patent term extension. It's a little bit different depending on country, but like in the US, you can get up to 5 extra years, I believe. If your drug compound that's patented spent a long time in FDA approval, so you can extend your patent monopoly to sort of make up for the time that was lost while you were waiting to get FDA approval. But in general, yeah, it's 20 years. And then as soon as your 20 years is over, whatever it is that was covered by that patent is now, in the public domain.
Right. And so, we've obviously been talking about the ways in which these might not be novel, and we mentioned kind of ancient indigenous use being a big part of this. And there seem to be a few interesting things going on at the moment where, on the one side, you have Compass again, who filed a patent in Mexico for psilocybin, which, given that that's the place that the indigenous use kind of gave it to the rest of the world in modern times, that strikes people as a kind of, ethically dubious thing to do. And then on the other hand, there's this group, Journey Collab, who have developed mescaline therapy for alcoholism. Again, Native American groups have used mescaline containing cacti successfully to treat alcoholism. So you may kind of see a problem there, but they've actually been including indigenous communities as stakeholders, right, in their model. So do you think there's like a way to kind of engage with this aspect kind of ethically in the space?
Yeah, I definitely think so. And I have really been inspired by the work of Journey Collab, and I've really seen the work that they've done as being a really tremendous model for kind of balancing the kind of the ethics of doing business in the psychedelic space and the ethics around getting protection by patents on a compound with the sort of imperatives of kind of having to look to the the source of some of what the inventions are, where they may have came from, and ensuring that there's reciprocity given to that. And I think that the work they're doing is it's an important sort of model, I think, for others. I mean, I would love to see others follow that, but I think they have. And I mean, part of why I'm excited about sort of ethics in the psychedelic space is because I feel like the overall ethos in the field is such that like there's a real room for people to kind of examine these different types of opportunities and sort of reimagine how they want to do business. And I'm excited as a patent lawyer in the space because it allows me to sort of think outside the box of just filing patents and just seeing them as something that an individual company uses for protecting its kind of own space, and thinking how patents can actually be used in a more supportive or more cooperative way with others. And so I think there's definitely a unique culture in the psychedelic space that sort of demands that these these interests and these different stakeholders be, their interests be considered. But that means that there's also, a lot of room for kind of creative, innovative thinking that goes beyond just something that's protected by a patent, but even, creative, innovative thinking in business models and business kind of dealings too, which is, exciting place to be.
Yeah. So we'll go more into the kind of, I guess, intermediate ground of what can be done in this space. But on the one hand, you have the kind of, patent, put it through the the kind of medical route. And on the other hand, you have the kind of decriminalization, legalization route. And this is also actually, I think this is the last time I'll mention Compass. But I think there was also a case of, again, talking about monopolization, where you have this Measure 109 in Oregon that successfully passed to legalize psilocybin therapy. And there were reports that the CEO, George Goldsmith, had been contacting researchers at a local university to mobilize opposition against legalization, which it fits with the kind of, as we said, we're not trying to kind of read people's intentions, but it fits with a perspective of an intent to monopolize or to profit in a way that's limiting access, that where you see legalization or decriminalization as something that's going to kind of impact your bottom line instead of, so it comes back to this kind of profit over access route. But do you think decriminalization, do you think we'll see a kind of patchwork where like certain places might decriminalize, certain places might legalize? Are there lots of different kind of routes that we could take here?
Well, yes. I mean, I don't have a crystal ball to understand exactly how that will unfold, but I think we will see. I mean, I'm very hopeful we'll see. I mean, I think, decriminalization should have already happened. It should happen as soon as possible. I really like the legalization model in Oregon. And, we were talking about this alternative universe of where maybe drugs wouldn't have to go through FDA approval to be, used as medicines. And the Oregon model kind of presents one possible alternative universe for that. Although, of course, psilocybin's a medicine that's not entirely new or really new at all. So that's, one kind of caveat. But yeah, I mean, I definitely see, going to Compass, like, of course, if you have a kind of single fixation on profit maximization, you're going to want to limit these other avenues as much as possible. I mean, I don't, I think that's certainly what they say on their website is that they see the medicalization route as being the correct route, and certainly what I've heard. And I think there was just another opinion piece from a psychiatrist who's affiliated with them, maybe within the last week, about how retreat centers really shouldn't be allowed to operate, or it's not appropriate for them to operate. And you can, I don't know his intentions behind it, but it is part of a bigger picture of wanting this to be through a very specific route to access, because the revenues from that route to access flow back to a single company. And so, that's definitely can be seen as problematic. And that's, one thing, however, that the patent system is really designed for. I mean, when a patent is granted, it means that that period of 20 years, the person that benefits, or the company that benefits from that, is, the patent owner, and that patent owner is generally a single entity who is able to kind of extract all of the value from that invention. So that's the sort of baked into the design of the patent system.
Right. Yeah. And the value of this, I mean, if they were successful, they could be looking at billions of dollars, I'm assuming, in terms of, as you were saying, with the pharmaceutical industry, there's a lot to be made. And it's not controversial to say that a lot of people are looking at psychedelics as potentially revolutionizing mental health care treatment. So if you do have a monopoly on it, yeah, there's a lot of money to be made.
Mm-hmm. Yeah, I mean, that's absolutely true. I mean, I think that's what excites many people about this space. Obviously there's people in this space that are excited about the fact that it is potentially transformative of mental health care, or for cultural reasons, or for other reasons. And there's a lot of people who I think are excited about it because of the potential for profit from those things.
Right. And so when it comes to other approaches, I think it's interesting to compare this kind of for-profit thing that's happening with psilocybin and Compass to what's happened with MAPS, the Multidisciplinary Association for Psychedelic Studies, and they've been a huge player moving forward MDMA-assisted psychedelic psychotherapy, but they're a non-profit, right? I think Usona as well is another example of a non-profit. How does kind of non-profit drug development sit alongside this for-profit model?
Yeah, well, that's a good question. I mean, I think we know where it sits now to some extent. I mean, we've seen it be very successful with both of them. I mean, MAPS is, of course, the furthest along with their MDMA in phase 3 trials. But the question, I think, will be how successful can that continue when there are, other ways for people to make money now in the psychedelic space. And, I'm not really super familiar with their kind of fundraising efforts and who they've been raising money from, but there's certainly a question whether some people that gave MAPS money 5 years ago did it because they were really excited about seeing psychedelics being more mainstream and being adopted as potentially medicines. And those same people may see that now there's a way that they can continue to support that effort, but also make more money back from it. So I think there's still a difference with MAPS, because MAPS, I think, kind of has two goals. And one of them, of course, is to be able to turn MDMA into medicine. And the other one is really to look at drug policy more broadly and to find ways to sort of push forward to having this, licensed, I guess, model where people have access to psychedelics, not just through their physician, but for other purposes too, which many of the for-profit companies probably won't be doing right away. Although I guess if we see legalization efforts take place, there may even be investment opportunities there too for adult use or kind of recreational psychedelics. So yeah, I mean, it's a definitely a counterexample to the necessity for patents to support clinical research and FDA approval of a drug. But I think it's also potentially just sat at a very unique sort of period of time where there was no other kind of way for somebody to get involved in this industry. I would like to think that that's either something that will continue or maybe there'll be a balanced approach. And I think we are seeing, some of the investment funds taking something of a balanced approach, similar to like Journey, like Vine Ventures has set aside, I think a full half of their like general partner profit toward a trust that gives back to the community. So there's people who are thinking about ways to kind of balance the profit maximization and the sort of public benefit aspects of things. And I've not kind of done a survey, but I think there's many more companies who are public benefit corporations than there are in a lot of other startup spaces. So hopefully people are taking these things to mind. Maybe answer your question. I don't know that there's a perfect answer to it. I think we'll have to see if MAPS can continue. I know MAPS. I think I heard Rick say once that he felt like MAPS will have done their job if like people didn't remember MAPS in the future, because they've like these things have all been they've been sort of destigmatized and now they're available for people to access. But I mean, I would like to think that like people would still be, if not MAPS still in existence, but like following that as like another alternative model to bring drugs to market. And I guess time will tell them.
Yeah, you mentioned early on in the conversation that there was an aspect where nonprofits like MAPS can get exclusivity to certain aspects of the process. I think you mentioned data. How does that work?
Mm-hmm. Yeah, so in the US, the first company to bring a particular drug to market gets 5 years of data exclusivity, which means that all the data that they used that supports their drug approval, nobody else can use that for 5 years. So like when MAPS, from the start of filing their investigational new drug application, their IND, which included all their like, preclinical sort of toxicology data, and then all the data around the, formulation of MDMA through their like phase 1, phase 2, phase 3 trials, all of that can't be used by another company. I mean, without MAPS's approval for 5 years. So it means that if another company wants to get MDMA approved for either also PTSD like a generic or for another indication, they would have to start from scratch basically and do everything from the kind of stability studies with their GMP MDMA through like the initial toxicology studies in animals. I mean, everything that could rely on any of that data. Outside of the US, there's also a period of what's called market exclusivity, where somebody's not allowed to sell a drug either. Would be the same, in addition to the data exclusivity. So like in Europe, there's actually up to 11 years of data and market exclusivity, which would give MAPS, potentially 11 years of exclusive ability to sell MDMA. But in the US, it would be 5. And I think maybe 6 months or a year later if there's like pediatric exclusivity added on to it. But basically it just means that like there's no easy way for a generic to kind of piggyback off that information and launch a generic equivalent.
Right. And I've seen you write about speak about this idea of an IP commons as a kind of intermediate ground of in the debate of whether to patent or not to patent. Can you explain kind of what that is and how that would work in this space?
Sure. So I guess looking at the kind of two extremes on a spectrum of like ownership, like on one far extreme, you have everything is in the public domain. So everything's accessible, everything is just open for anybody else to use. And then the other extreme, there is like complete enclosure by individual companies, where like every company would have a patent on whether it's a compound or a way a compound is used, and there would be all these competing kind of rights that companies would have to exclude others. So a commons would be sort of a way of looking at IP that sits somewhere in between it, where companies can sort of work together to contribute IP to a, either a kind of like another organization that would be able to manage like the IP of a group of companies, either for like their own benefit or for the benefit potentially of like third parties. So you can imagine, for instance, with like a psychedelic assisted therapy clinic, say you want to open up, and say there are a number of competing patents in the marketplace that people have on, like, somebody has one on psilocybin assisted therapy, and someone has one on DMT assisted therapy, and someone has one on psilocybin assisted therapy for anorexia. Like, the clinic is going to have a lot of sort of transaction costs to kind of investigate where all these rights are coming from and try to license different ones. And it makes it difficult, I think, for, in this example, for like a clinic to be able to sort of start. So the commons could work together to like kind of pool those rights and find a way to make it more efficient to, like, for instance, license those to, to that clinic. But the commons can be used in a lot of different ways. And so I think, like, when I think about commons, there's kind of like a legalistic way, which is like how it's structured, which is like looking at the like administration of it and the kind of like legal documents that kind of control it. You could also look at it in terms of what people are contributing. So people can contribute either like IP, like whether it's patents, or could be potentially sort of any other kind of IP they have, whether it's research data or sort of patient data. And you can also think of the IP, which I think is probably the most valuable way to think of it, as a kind of someone who's new to it, which is sort of what does it offer? What can it benefit to people who are sort of partaking in the commons? So, one of the ways, which kind of reflects back on some of what we talked about earlier, is just protection. So people in the commons can come together to do things like identify problematic patents that somebody else may have filed and find ways to try to assure that those patents don't get granted. They can find ways to put provisions into their own patent kind of licenses so that like a troll is not able to acquire their patent and then start suing people in the psychedelic space. They can also sort of work together to try to have something similar to like a kind of, I don't know, like a non-disarmament trust or something, like where, trying to think of what the name is for it in like the military setting, but like a non-aggression pact, I think, where, they kind of agree not to either sue each other for specific things or to like not take certain abusive practices, because there's a concern when people have patents that they're going to be diverting their kind of resources and energy to policing the boundaries of their patents rather than continuing innovation or otherwise kind of benefiting the ecosystem. I mean, so, there's ways to try to like remove or sort of change those incentives a little bit. So protection is like really kind of the foundational one, I think, for a commons, but there's a lot of ways that members of a commons can use their IP to cooperate too. So rather than just to compete over their rights, but to find ways to cooperate over them. So, the example with cross-licensing rights to be able to offer to like a therapist or a therapy center, I think is kind of one good one. But also, you can, for instance, if you pool your patents, you can securitize them and potentially use them as collateral to offer like loans to people who want to start a new business or want to start a clinic. So there's ways that like patents, if they're assembled together by members of the commons, can create sort of new rights or new opportunities for members of the commons or members of the, or like other entities that members of the commons want to support. And sort of a third one, I think, or third benefit of a commons would be to take these ethical principles and actually turn them into legally binding requirements as part of an IP license. So that can be done individually by companies, but it can also be done in an organized way where if enough companies together kind of create a critical mass where they want to put these rights into their IP licenses or into the kind of way they contract around their IP, then they're able to like make that a kind of cultural norm that has the ability to kind of transmit those principles to others who may be like kind of newer to the space or getting into the space. I mean, I think the psychedelics space is still pretty young, and that, you know, even though there's a lot of ethical concerns now, a lot of companies are really still approaching the, you know, the field in a way that's like they're trying to be intentional about like sort of doing good, but that may not be true as like it kind of gets you know, bigger, and as there's more money to be made and as there's more patents that get granted. And so there's, I think, going to be a developing concern about companies like continuing to have those sort of good intentions. And like people may be concerned now about Compass, but you know, they are, you know, maybe doing some things that rub people the wrong way, but like, are they really a predatory kind of actor? And what would it mean for there really to be predatory sort of actors in the space? So there's, you know, ways that a commons could be used to like make it more difficult for those sorts of like kind of worst case scenarios to come to pass.
Right. And this may be a slightly weird question, but is there any, you know, a lot of the time when people are coming with these patents, it's to cover kind of risk, right, of the investment. But in this case, these things, I mean, I don't want to get ahead of myself, but I feel like they're fairly sure bets in terms of when you look at the academic literature. But is there a risk that, you know, one scenario I can imagine would be, you know, say Compass gets this kind of monopoly on patents for synthesized psilocybin delivered through clinics, but then, as often happens in the states, where the states kind of, you know, set the way for what can often happen at the federal level. Say at a federal level, they decide to adopt something like what happened in Oregon, and now therapists are allowed to use, you know, organically grown, just normal natural mushrooms, instead of, you know, having to go through this route. Is there a possibility that at some point down the line, these companies could end up basically failing, where there's just a cultural shift that means that they're no longer relevant, their mode of delivery isn't relevant and profitable?
Well, I think it's, you know, I don't know that it's going to be that they fail entirely. Like, for instance, my parents know that I enjoy psychedelics, and I've had mushrooms, for instance, you know, around them, and like, I don't think, however, that they would be interested in kind of experimenting with them themselves. I feel like if they had the opportunity rather to go to a clinic where they could get a synthesized psilocybin compound from somebody who they knew passed, you know, some specific set of, you know, very particular like requirements, that they were, you know, clinically trained psychologist or, you know, an MD and a psychiatrist, I think that's going to make them much more comfortable. So I think, you know, there may still be people who, you know, for that reason, or maybe for insurance purposes, you know, if these are approved medicines and insurance covers them, you know, maybe that's going to create the opportunity. But certainly, I mean, just going back to like what we talked about before about how that's a concern that we would think Compass may have about like there being legalization in Oregon. I mean, if many states allow people to get, you know, psilocybin-assisted therapy just by having natural mushrooms, I mean, I think given the, you know, the difference in cost, that's certainly going to be an option that many people are going to take. I mean, I would certainly rather do that, I think. And I think that will also open up more avenues for kind of experimentation in how these are delivered. So for instance, in Oregon, I think it may be possible to have like group therapy, but I don't know that like that would be something that would be very easy or even possible through the FDA. I think MAPS was like trying to figure out if that was something that the FDA would ever approve, group therapy or like couples therapy. But so there may even be avenues that people can take to specific types of psychedelic assisted therapy that, you know, wouldn't even be part of an FDA approved sort of process. But yeah, I mean, I do think that every state that goes, you know, that allows a legalized framework, you know, as more and more of those become possible, that's, you know, less and less for the medicalization route. I mean, there's, you know, obviously there's going to be a very big market, I think, for this, as you know, the kind of fallout of the coronavirus pandemic and, you know, the ongoing mental health sort of crisis. But you know, that universe is still limited in size. So, but I mean, my hope, of course, is that there's, you know, real diversity in how these are delivered. So I am keeping my fingers crossed that we'll see lots of states have, you know, campaigns similar to Oregon, and even broaden them beyond, you know, just psilocybin, because, you know, it's a way that psychedelics can not just kind of transform mental health care delivery, but really like mental health care and healthcare itself, and, you know, even go beyond kind of healthcare to being used to, you know, just benefit, you know, people spiritually or creatively, or, you know, Bob Jesse's betterment of well people, I guess, would always come to mind.
And I'm very interested as to what your ideal kind of picture of what the space might be like in future. You mentioned diversity. Do you think that's the kind of ideal thing, where there's lots of different routes to access these things?
Yeah, I mean, that would be my hope, because I think the potential for psychedelics is far beyond just, you know, what taking one compound or taking a handful of compounds through FDA approval for specific clinical indications, even if they're used ultimately off-label. So I think there needs to be space for people to explore how to use them, and, you know, the different ways. And I think we're still going to see that. I mean, now people are looking at different ways of combining digital tools, and I'm sure, you know, in a year or two, people are going to be wearing all kinds of EEG headsets and have all kinds of different, like, you know, AI connected devices and biosensors and biofeedback and, you know, generative music. And there's going to be a real flourishing, whether it comes from the sort of more standard medicalization route or not. But yeah, I mean, I think, you know, this has been an area where people have been already experimenting. I mean, after I had my first psychedelic experiences in college, I think I was so obsessed, I spent like, I don't know, 6 months reading everything on Arrowhead. So that you can imagine that, like, the, you know, the space for experimentation with these is enormous, and it's, you know, it's only going to get bigger and bigger once more states, you know, decriminalize, and more people are able to, you know, talk about these things openly, and, you know, practice these things openly.
Yeah, I can definitely imagine a huge culture shift, a big explosion in interest in the mainstream. And you mentioned early on active in the cannabis space. Are there interesting differences or parallels in how things have unfolded over recent years with cannabis?
Yeah, I mean, I think cannabis probably offers a lot of sort of warnings to psychedelics, because I don't know how many people look around at the cannabis space now and think that that was kind of the optimum situation that they would have wanted had they set out to build something. I mean, both because there's, you know, still a lot of ongoing issues around equity, also because even people who are interested in it as just an investment opportunity lost a lot of money, and it's not done really well there either. But I think that the situation in cannabis is not really one to be repeated, and that's a whole podcast itself, because there's so many differences in different states and how they've approached things. But I hope I know that people are, you know, in the psychedelic space who are thinking about legalization, decriminalization efforts are, you know, pretty conscious of kind of what happened in cannabis and what went wrong in cannabis and trying to avoid those mistakes. So I'm, you know, hopeful at least some of them won't be repeated. But yeah, there's a lot of interesting parallels. I mean, obviously, there's a lot of differences too. I mean, you know, we're not going to see, at least right away, I don't think, like, you know, on every, at least in San Francisco, it feels like in my neighborhood, on every street corner, there's a shop I can go into and get a, you know, branded box of THC gummies. I don't think it's going to be quite like that right away with psychedelics, but
yeah,
we'll see down the road.
And you mentioned at the start Psilocybin Alpha and this patent tracker that's been served there. Can you tell us a bit about that?
Yeah, so Psilocybin Alpha is, you know, it's a resource that Josh Hardman, who's the kind of the founder and editor of it, started. And my patent chart, the psilocybin one, actually just kind of came to his attention because it was like, I think I posted it in a Twitter thread and it was like indexed by Google. And then he reached out to me and asked if it would be okay to post it. And I said, yeah, it would be fine, which was probably the best decision I've made because kind of our relationship just as friends and as colleagues has been a really important one to me, both kind of understanding the space and being involved in it. But yeah, I mean, you know, part of my interest in making sure those trackers are there have been because, you know, both out of my own curiosity, it's been really interesting to see this sort of explosion in patent applications. But I think it is a conversation that I'm, you know, like I said, I'm glad we're having it, but I'm, you know, I think it's a necessary one for people to kind of understand how ownership rights may like start to crystallize in this space.
Well, thank you so much for your time, Graham. This has been excellent. Where would you send people to if they want to look into your work more?
Well, I have a website, calyxlaw.com. I spend most of my time, probably more time than I should, on Twitter because that's I end up. If I'm working late at night, I know it's because I spend too much time on Twitter during the day. But that's generally where I can be found in conversation. Calyx Law.
Great. Yeah, I definitely recommend following Graham on Twitter. It's I found it incredibly valuable, and this has been really valuable as well. So thank you again for your time.
Yeah, well, I really appreciate it, and I've had a great conversation. And you know, there's always so much more left over after it. So I know I'm hope to continue talking about these things on Twitter and elsewhere. And yeah, thanks for inviting me on today. It's been a lot of fun.
Yeah, absolutely. I'm sure there'll be lots of interesting developments to talk about in future. So maybe we can do this again sometime.
Yeah, absolutely.
Great. Thanks for listening. If you're watching on YouTube, please like and subscribe. And if you want to help the podcast reach a wider audience, you can leave a review on Apple Podcasts. Finally, if you want to offer financial support, you can go to patreon.com/Dr. James Cook.